ready to get started with our second panel. Our moderator for this panel is Augustine Lowe, and I will let him make the further introductions to the topics of the panels and our speakers. Thank you.
Good evening, everyone. Thank you for joining us this evening. We have 4 excellent panelists that are joining us for the second panel. As you saw, the first panel was geared towards broader issues in trade relations between the United States and China. Well, in the second panel, we're going to talk more about concrete disputes, concrete points of tension between these 2 trading partners. As a bit of introduction, I'm Augustine Lowe. I work at Dorsey & Whitney with Bill Perry in the first panel. I've had the fortune of meeting quite a few of the panelists this evening. I've had the fortune of working with Judge Pogue. I've had the fortune of working with Chris Cloutier, and I've had the fortune of having Professor Kovacic as my first-year contracts law professor. So with that, I will start by introducing Mr. Noah Haft, who will be our first speaker. Noah Haft is an alumnus of Brooklyn Law School. He is currently the head of International Institute for Conflict Prevention and Resolution. Prior to that, he was general counsel for MasterCard. And so in that role, he knows quite a lot about the difficulties of American companies entering foreign markets. And he also now has expertise in resolving international disputes through arbitration.
Thank you, and I'm delighted to be here. And let me start by getting something right from the start understood. The gentlemen that are on the panel with me are experts in this field. I'm not. Not that I'm an imposter, but I come with a different perspective, having been a general counsel of a global company and now CEO of the International Institute for Conflict Prevention and Resolution, which has given me some understanding of how corporate lawyers think about doing business in different parts of the world, and in particular China, and how they view the best options from a contractual perspective. And I think in talking to many general counsels, many in-house lawyers, I think there's no question that there's a common view that a reliable and reasonably predictable legal system is really essential to a country's success in global commerce. In fact, this view is the foundation of the approach taken by the World Bank and the IFC, in which improving capacity for dispute resolution plays an integral role in economic development. It was also critical to the founding of my organization, CPR, which is a global organization that was formed almost 40 years ago to find new and better ways to resolve disputes. Our members include multinational corporations around the world and are drawn together by a collective view that, generally speaking, litigation is not the answer, and that enhancing that global capacity for fair and reasonable dispute resolution and the ability of individual companies to improve their effectiveness in resolving disputes is essential to the success of their business. This has led to CPR being recognized. CPR is the acronym for Conflict Prevention and Resolution. It's led to our being a leader in driving mediation and arbitration around the world, and also what I would refer to as preventative law practices. We've been a driving force around the world in propelling ADR through education, tools and resources, and advocacy. In addition, we provide, like CTAC in China and like the AAA and ICC and many other organizations, administered arbitrations and mediations around the world. In our work, we see a proliferation of cross-border issues, contracts, and of course disputes. And arbitration has clearly become the preferred means of resolving disputes amongst almost all in-house lawyers and amongst all corporate lawyers generally. Of course, in every contract, the seat of an arbitration, the arbitral organization, and the rules to be applied are all points of negotiation. Alternative dispute resolution certainly works best and is most effective when there is trust in the legal framework of a particular jurisdiction. Although China has made great advances in arbitration practices, including a greatly improved record in enforcement of arbitral awards from foreign jurisdictions, and improved results for foreign parties. Few, if any, corporate counsel would choose China as a forum for disputes unless they had to. That's the reality. I believe this is in part because there continues to be a fundamental lack of trust in the legal system and ongoing concerns about independence and government influence. One of the things that feeds these concerns are individual experience that companies, that individual counsel experience. And global companies face this all the time. I'm going to take a minute to turn to a WTO experience faced by my former industry, the payments industry. 2001 was a memorable year in that it was the year that I became general counsel of MasterCard Worldwide. It was also the year that China joined the WTO and agreed to open its market to electronic payment services. There is a lot of complexity involved in commitments that were made, but essentially, at bottom, China agreed to provide national treatment to foreign networks, essentially meaning that you could not discriminate, that China could not discriminate in favor of domestic payment providers. Now, China UnionPay, which some of you may be familiar with, was created by the People's Bank of China, the PBOC, and has for a long time been the sole domestic processor in China. MasterCard, my former company, has a long-standing, excellent relationship with China UnionPay, the PBOC, and the Chinese regulators. And in fact, in China, a number of Chinese banks issue credit cards, China UnionPay or cup cards, branded MasterCard. These cards work as cup cards in China and MasterCard cards outside of China. But none of the international brands had access to the vast, exciting, and increasingly important domestic Chinese market. This precipitated a case that was brought by the United States against China in September of 2010. I'm going to dramatically oversimplify the case in the interest of time. The allegation essentially was that China created a market allowing only for a single provider, thereby denying access to competitors for domestic payment services. In a WTO finding in July of 2012, the WTO held that China violated its obligations vis-a-vis non-discrimination and provision of market access for foreign networks and set out a compliance date of July of 2013. I think what happened is illustrative. Although China did repeal some discriminatory measures, it failed to issue enabling registrations. And so as a result of that, at this point in time, there is no competition in China for domestic payment services, and the international networks are precluded today from participating in the Chinese payments market. In Congress's year-end report on WTO compliance, it noted that despite announcements that the market would be open, China still has not taken steps to do so, and U.S. payment providers remain blocked from China's vast domestic market. So I'm just going to conclude by making the following point. Trade disputes, in my mind, are inevitable, which is the very reason a reliable and predictable mechanism for resolution needs to exist, and why it's so important. If China continues to improve its arbitration processes, and most importantly instills some degree of confidence in its legal system, things can change. In-house counsel that talk to me every day about avoiding China, like the plague, to be totally candid, can move towards, can really be turned around, and China can then realize the extraordinary potential that everyone knows that it has before it. Thank you.
Thank you, Noah. And so for our next panelist, Christopher Cloutier, he hails from Washington, D.C. He's a partner at King & Spalding. Prior to that, he was acting Deputy Director of Trade Remedy Compliance at the U.S. Commerce Department's office in Beijing, which works under the auspices of the U.S. Embassy. He is fluent in Chinese, has extensive experience in countervailing duty cases involving China, both in U.S. law and WTO disputes, and he frequently represents U.S. companies in these disputes. Well-known fact, at law school, he was a law clerk to Vice President Al Gore, and if you'll perhaps start by, I don't know, perhaps you could present a rebuttal to Joseph.
Yeah, actually, I do plan on deviating a little bit from what I planned to say. And the first thing I need to correct is, I don't know who keeps putting fluent in my biography, but that's really got to come out. I lived in China from 2002 until about 2006. And my job, well, let's go back. As you've heard several times, China joined the WTO at the end of 2001. The United States Congress allocated a certain sum of money for trade lawyers to go over to Beijing, to live there, to watch over things on a day-to-day basis. So part of my task in the early days was to watch China's implementation of its WTO obligations and report back. I was particularly interested in China's use of trade remedies like anti-dumping and countervailing duties that you heard about from Mr. Perry. As prior to its WTO accession, China had conducted a handful of anti-dumping cases, but not under the WTO rubric because it wasn't a member. But now that it was a WTO member, it had to do anti-dumping and countervailing duty cases under the WTO rules. And I was there to watch the process, try to figure out what was going on, and then to be in a position to help U.S. companies who became involved in those types of investigations by the Chinese government. In terms of some of the things, I guess, Mr. Perry obviously feels very strongly about non-market economy status, and in particular the buildup of the factors of production that the Department of Commerce uses. I would point out that notwithstanding all of this, China still has a $315 billion trade surplus with the United States. Anti-dumping, although it's a big topic in a lot of Chinese press, it really affects maybe 1% of trade for most countries, maybe 2% at the outside. So although this is an important factor for those companies involved in actual trade investigations, you shouldn't view our bilateral trade relationship only with respect to anti-dumping. 98% of trade, 99% of trade is never subject to a dumping case. This is just trading goods. That has nothing to do with trade and services. So most of our trade, the vast majority of our trade, is never affected by an anti-dumping case and probably never will be. Another thing that Mr. Perry acknowledged was that anti-dumping goes both ways. China, shortly after joining the WTO, embraced the anti-dumping agreement and began to initiate cases against the United States at a record rate. It's really been impressive. MOFCOM, the Ministry of Commerce, which is also one of the antitrust regulators that Professor Kovacic indicated, is the primary investigating authority. I've always found it interesting that the entity that is responsible for determining whether the Chinese industry is injured is a group of former industrial planners. So people who had a lot of experience helping the Chinese industry to develop were now sort of the police who were in charge of making sure that it was not harmed by foreign imports. Sorry, I'm keeping this. I have 5 minutes, right, Augustine?
You do. You have maybe 2 minutes.
Oh, very good. So that brings me just to one example of, since this panel is supposed to focus more on like actual trade disputes as opposed to the big picture. Back in 2006, the United States initiated its first subsidy case against China. This broke 20 years of precedent that you heard about, where for a long time the Department of Commerce said we can't look at non-market economies for subsidies because it's really just this branch of the government giving this other branch of the government money, and it's all the government, so how are we supposed to measure what part of that is a subsidy? In 2006, my firm was successful convincing the U.S. government that in fact in the modern Chinese economy you could find when one branch of the government was giving money to another branch, a productive branch. Because for those of you who have lived or worked in China, the work units that used to exist and were part of the governments are no longer there. These producers, they have corporate form, and they're corporations that are distinct from the government. The government may own them, but it's distinct, and you can measure the flow of money between those. Shortly thereafter, China initiated its first countervailing duty case against the United States. And this was something where the Chinese authority had a lot of experience with anti-dumping. It had no experience with countervailing duties. And for example, U.S. steel companies the subject merchandise was grain-oriented electrical steel. It's used in converters and transformers on power lines and things like that. So U.S. companies the Chinese industry alleged that U.S. companies were benefiting from the below-market sale of natural gas by the U.S. government to the steel industry in particular. And this was based on a document from 1930. Those of you who are old enough might remember that President Reagan famously deregulated the natural gas industry in 1980. So this allegation really had no basis in fact, yet U.S. companies were forced to spend considerable resources responding to this allegation and had to in fact report the prices they paid for natural gas, who they bought it from, and when, which is all competitively very significant and usually confidential information. I would point out also that at the end of the day, the Chinese government found a couple of minor subsidies by like county governments, most of which amounted to not much of anything, but then imposed duties anyway because the U.S. companies had refused to answer questions about a certain subsidy program they didn't use. And that was the basis for the whole thing, which became a WTO dispute and remains. So, I look forward to your questions.
Thank you, Chris. Okay, and so now that we've heard from some practitioners, we will now hear from some law professors. Professor Jolyon hails all the way from Hong Kong. He's perhaps the one who's traveled furthest for this panel. And at Hong Kong, he has extensive experience with arbitration. He is an arbitrator of the Hong Kong International Arbitration Center, the Guangzhou Arbitration Commission, the South China International Economic and Trade Arbitration Commission, among other panels. He is therefore quite familiar with the CTAC arbitration process in China. Also, incidentally, he is a member of the International Institute of Space Law in Paris. So with that, Professor Zhao, perhaps you can explain how the process works.
Okay, thank you very much, Chairman. Good evening, everyone. I think it's a great pleasure for me to be here. So I think today I would like to talk about something on the commercial arbitration in China, and especially for the U.S.-China trade disputes. I understand, I think today was around 5 minutes, I think, to go through, or possibly a little bit more, but I will try. So I think arbitration, I think basically I would like to go through like what will be the legal framework and also arbitration commission, etc. Since the open door policy, arbitration has become a very important way to resolve disputes. And it's very important to see that in China, I think we already have very important arbitration commissions, especially when we look at the CTAC, China International Economic and Trade Arbitration Center Commission, and also China Maritime Arbitration Commission. So I think these two arbitration commissions are very important. I think basically, I think in first stage, they can receive a lot of international cases. I think basically we have these two arbitration commissions which monopolize all the international cases. And after 1995, after the arbitration law was released, then a lot of local arbitration was set up, and these local arbitration commissions can only receive domestic cases. But very soon we can find out that these kind of borderlines, I think, actually have been blurred, which I will come back very soon. When it comes to sources of arbitration regulation, basically we have the arbitration law in 1905 and then a lot of other laws, which I don't think I will go further with that. Arbitrability, of course, I think very important to see what kind of cases will be brought for arbitration. We can find out that when a lot of cases can be brought forward for arbitration, I think civil and commercial disputes, and which of course we can find out that U.S. China trade disputes, a lot of cases I think related to trade issues. China adopts a very interesting system. I think one of the very important issues regarding the bifurcation between CTAC, CMAC, and local commissions, as I've mentioned in the very beginning, CTAC and CMAC can only receive international cases, and local arbitration commissions can only receive domestic cases. But very soon, in 1996, only 1 year after the release of the arbitration law in China, then very soon we can find out that CTAC, CMAC can also receive domestic cases, and local arbitration commissions can also receive international cases. So I think basically now we can have a very competitive environment. You can decide which arbitration commission you can go to. For example, I'm arbitrator of the Guangzhou Arbitration Commission, so I think basically I can receive quite a lot of international cases. I think several months ago I have received a case, I think between the disputes between one American company and also Chinese company. So I think it's very interesting to see all these new developments, I think very competitive. And then another very important dual track system, I think actually regarding the difference between the domestic and foreign related arbitrations. In a way, we can find out that domestic arbitration receives less favorable treatment compared with the foreign related arbitrations. In China, we found out that ad hoc arbitration is not possible. We only accept institutional arbitration. That means in the arbitration agreements, you have to make it very clear that which arbitration commission you would like to use. So I think arbitration agreements, you should include 3 elements. One is intention to arbitrate. Second, arbitrable matters. And third, designated arbitration commissions. So in very beginning, we have been very strict with the arbitration commission. If you do not put down, for example, the CTAC or CMAC, then the arbitration agreement will be invalid. Now, we relaxed a bit the requirements for arbitration agreements. If you simply put down the location, for example, Beijing, of course, I think we know in Beijing at least 2 arbitration commissions in Beijing. One is the CTAC, the other Beijing Arbitration Commission. So you cannot decide which arbitration commission you are referring to. So I think this will not continue to be invalid. But if one city, there's only one arbitration commission. So for example, if you refer to Hangzhou, there's only one arbitration commission, for example, Hangzhou Arbitration Commission. So if you simply write down the city of Hangzhou, the arbitration agreement will be valid. So I think we can find out that the trend in China is to be more pro-arbitration. And then there's also some other elements, severability doctrine recognized, and also competence issues. So I think these has been well recognized, I think, or not recognized, has been indirectly used in the CTAC rules. Another very important element regarding the arbitration in China, basically the mid-arb. I think that means we can combine mediation and arbitration. So I think basically we can find out that you receive the cases first, then arbitrators will simply tell the 2 parties, possibly we can start with the mediation. So I think that's one case which I sit in. I think basically I will start with the mediation first. If the 2 parties can resolve the dispute, then of course we will be happy to see the settlement agreement. Then we will change from the mediation to arbitration. That means we can change the settlement agreement to arbitral award, which makes the arbitral award, settlement agreement binding. So I think that's one. And interim measures, I think in China, I think the court will take over the power, interim measures. The arbitral tribunal will not have the power. And qualification of arbitrators in China, I think slowly we have a high quality arbitrators now. And also we can find out the rules which were put down in arbitration law, I think provides lots high requirements compared with the judge. I think it appears to be much higher. Because we can find out, for example, 8 years experience in arbitrator, but if you would like to look at the judge, basically you can, for example, in a people's court, if you work for 2 years, then you can change to judge. So in a way, we always joke that the quality of the arbitrator can be higher than that of the judges. Challenge or withdrawal of arbitrators, I think this is basically the same. I think, yes. It's not very special. And then appeal of awards, I think this is one typical element that in China, I think as I mentioned, the bifurcation of the 2 regime. We can find out that in the international arbitrations, basically you can only refer to the procedural issues. If there's a problem with the procedural issues, then of course you can apply to change or set aside the arbitral award. But for domestic arbitration, basically you have to refer to the procedural issue and also the substantive issue. And as I mentioned, arbitration commissions in China, there are more than 200 arbitration commissions already. And we have already mentioned about like the enforcement issue. I think arbitration provides a very good environment for arbitration enforcement issue. But I think in the last few years, there's also a lot in the development. I think especially when it comes to CTEC, I think a lot of changes to the CTEC rules, especially by end of last year, 2014. I mean, so I think new set of the CTEC rules has been introduced. Also, very important developments regarding the online arbitration. So I think that will be quite interesting to see the new developments. So that's my presentation. Thank you very much.
Thank you, Professor. Okay. So thank you, Professor Zhao. That was an excellent overview of CTAC arbitration in China generally. Our last panelist is Professor Thomas Lee at Fordham Law School from this city. He has been a visiting professor at Harvard Law, UVA Law, and Columbia Law. He was on the board of the Harvard Law Review during law school, and he clerked for Justice Souter of the U.S. Supreme Court. And most interestingly, perhaps, he worked as a U.S. naval cryptologist. He has published many books and articles on international law, comparative law, including a particular article that may be in your packet on a concept called zeroing. He's on the ICSID panel of conciliators, among other distinguished positions. And with that, I'll hand over to Professor Lee.
Thank you, Mr. Lowe, and thank you, Brooklyn Law School. I'm going to be brief. I mean, basically, you have the articles. I just wanted to synopsize the article and sort of make, which talks about a case. And it's a case that both Mr. Perry and Mr. Cloutier have alluded to, so it should be familiar to you. The case involves a U.S. importer of pneumatic off-road tires called GPX. And the case started, well, essentially what happened was since 1984, the United States had treated China as had this idea that for a non-market economy, you could not assess countervailing duties because a subsidy just didn't make logical sense. Because if the government runs everything and the market isn't setting prices, it doesn't make sense to say that there's a subsidy. So the policy of the United States and the Department of Commerce from 1984 to essentially 2006 had been, if you're going to assess anti-dumping duties against a country that happens to be non-market economy, it doesn't make sense for you to assess countervailing duties as well. Well, that changed in 2006. Mr. Cloutier's firm litigated the case. The Court of International Trade of the United States actually ruled against the Commerce Department. And then the Federal Circuit affirmed the Court of International Trade on a different ground. And the Federal Circuit affirmed not on the logic of double dumping, but because they said, well, look, Congress passed major trade legislation in 94 and 88. They left this rule alone. So we can infer that they're happy with the idea that for a non-market economy, you can't assess both countervailing subsidy duties for subsidies and anti-dumping duties. But what happens, they won, as I say in the article, which I wrote with Professor Sung-Jun Cho, who actually is a trade expert. I'm an expert in federal courts and US litigation, so we did this together, and international litigation and arbitration as well. What happened was they lost the court battle, but they won the court battles, but they lost the war because the Congress passed a statute essentially saying specifically it's okay to, and I'm sure Mr. Cloutier's firm might have had something to do with that as well, that said it's okay to assess countervailing duties and anti-dumping duties. President signs it into law, so the court judgments don't mean a thing, right? So what happens? Round two, WTO, only members can be parties, so it's not GPX versus Department of Commerce anymore. It's China versus the United States, exact same issue. If you're going to adopt a non-market economy logic, can you assess both countervailing duties and anti-dumping duties? Panel report, the way the WTO dispute resolution apparatus works is you get a panel, and the quality of the panels are fairly uneven. The panel actually, I'm not trying to make a normative point about the merits of one side's argument or the other, but the panel, the Commerce Department, the United States wins before the panel. And then it goes to the appellate body, which is a more august kind of selective panel. And the appellate panel body reverses the panel report, and China wins. So that's where we are on this particular dispute. So what Professor Cho and I say in the article is, isn't it a shame that you had two sets of litigation on highly technical issues, and they don't even pretend to acknowledge each other in any way or fashion, right? And we say that there's a fear of subordination, the implication that one panel the U.S. court system is somehow subordinate to the international system if it acknowledges it. And we sort of talk about a model of engagement. So that's what we talk about, and sort of we use this debate to explore the connection between a U.S. A national judicial system and an international adjudicative system that decide not only the same issue, but the same issue on an incredibly technical question, and yet pretend as if neither really exists, right? So that's sort of the puzzle that we talk about here in the paper. One last concluding comment. I think a very knowledgeable person pointed out, and then Mr. Perry talked about the accession agreement and the fact that the time limit on non-market treatment for China may expire under the terms of the China's accession agreement within 15 years of their accession in 2001, which would be December 2016. That raises a very interesting issue for someone like me who observes the federal courts, because ultimately China will litigate this. If the U.S. government's practices continue, they will definitely litigate it before the WTO. And the likelihood is they will probably win before the appellate body. And so around 2020, a case might come up in the U.S. litigation system where the question is presented before the United States Supreme Court. Well, what do we do with this WTO adjudication saying that the Commerce Department can no longer apply the non-market economy logic to apply both countervailing subsidies and anti-dumping duties to China? And that raises incredibly interesting constitutional issues about the supremacy clause. There's cases called Sanchez, Lamas, and Medellin about this particular issue, the degree of deference that the Supreme Court owes on an interpretation of a treaty to an international adjudicative body. And that case probably will be queued up and litigated sometime in 2020 is my prediction.
Thank you, Professor. So, let's see. Do we have any questions from the audience? We have such a distinguished panel of both practitioners and law professors who have dealt with U.S.-China trade issues. Does anyone have any questions that you're urging to ask? If not, then I'll start with the first question. I heard a bit from, we heard from Mr. Hant, who mentioned the fact that many people are somewhat reluctant to choose China as an arbitration venue. We've also heard from Professor Zhao, who talked about the integrity of the panels in China. So perhaps we can have a question to the panel. If you were to advise a client or company to write an arbitration clause in their contract dealing with U.S. and Chinese entities or assets, where would you choose as the venue for a place of arbitration?
That's an interesting question. The first thing I would advise my client is to apply the new international conflict prevention and resolution rules that became effective December 1st. That's an easy one. I think in terms of an easy part of the question, in terms of seating the arbitration, I would say that most in-house counsel look to Singapore as a first choice. Obviously, there's a negotiation with a counterparty, so you can't always get what you want. But Singapore has become a very serious choice for a number of companies, and a number of companies do use the Hong Kong arbitral choice as well. So those are, I think, in terms of the compromised jurisdictions, the two most commonly used.
Excellent. So perhaps you and Professor Zhao are in agreement.
Yes, I think first of all, I think arbitration seat, I think obviously, I think very important. I think I agree with you. I think normally if we look at Asia, I think Singapore and Hong Kong would be the two best choice, I think, for the customers. But of course, I think if we look at the Chinese situation, I think we can find out that Chinese arbitration has a very quite different system, I think, compared with international arbitration in other cities. As I mentioned, that China has a dual-track system. Sometimes I think we can find out that international arbitration can receive favorable treatment. I think in a way, I think that will be good. But of course, I think the seat for arbitration, I think normally decides a lot of important issues. So I think in a way, I think Hong Kong would be a very good one. That's also the reason why CTAC set up branch in Hong Kong. So I think try to attract the customers. So I think that could be kind of a very sensitive way to develop that business. And also I think last year, I think one scholar have written one book regarding a possible seat for Macau. I questioned him, I think why Macau should be a very good opportunity seat. As he told me, I think Macau has very good system. And of course, I think they can use a very good system to attract people who speak Portuguese. So I think that could be a very good one. They can use English, Chinese, and Portuguese. That would be an ideal seat, not for all cases, but possibly for certain type of cases. So thank you.
Professor Lee, could you respond to that?
Yeah, I just wanted to add a clarification. There's a difference between choosing a place for the arbitration and choosing the arbitration center that's kind of known for that place, right? For example, I was just at an arbitration in Singapore. You could have an ICC arbitration in Singapore, or you could arbitrate before the Singapore International Arbitration Center, or you could have an arbitration in Hong Kong that's an ICC arbitration, or a CTEC arbitration, or Hong Kong International Arbitration Center arbitration. The one thing I would add that I think, at least in my experience, and I don't have a lot, but I do consult and help parties in this, many foreign parties don't mind litigate or arbitrating in New York, right? Whether before the ICC or some institution, and that's because they know that if they win, that the U.S. courts are going to be pretty fair about enforcing that award against the U.S. company, and they're not going to have to play the hunt for assets game, and they're going to have a judicial system that works for them. So obviously, by the same token, if the U.S. counterparty wins, they're going to have a harder time if if the arbitral award is distant from China. But I've seen situations in which at least Asian counterparties don't mind very much arbitrating in New York, and it's because the judicial system is so fair about awards.
Thank you, Professor. Now, going back to something that you mentioned during your presentation, the disparate ways that the courts have resolved the countervailing duty, anti-dumping duty issues in the notable GPX case. It's remarkable that Congress basically overruled the court in, what was it, space of maybe a year or less. And given the political environment in D.C., it is quite remarkable how fast both houses were able to approve that process and have it signed into law. Mr. Cloutier, could you perhaps speak to that?
Well,
Without violating law-client privilege?
well, no, I mean, it's no secret. The decision, it was actually months, Augustine, and it was bipartisan, and they were some of the easiest meetings I've ever had on Capitol Hill.
Yeah. Well, it goes back to what Mr. Perry was saying. I mean, it is political, right? I mean, these are political questions.
Well, the idea that some members of Congress were surprised that they had apparently acquiesced in this, in this 1984 court ruling involving fluorspar from Poland, and that somehow prohibited the application of countervailing duties against imports from China.
And so the net result is, within a few months, Congress has reaffirmed the fact that that United States could bring countervailing duty cases against Chinese imports. That's remarkable speed. All right. Perhaps we can also speak to a bit more about the NME methodology. We've heard many discussants discuss this topic. As some have said, that there appears to be a deadline written into China's accession protocol. It appears to be next year. The U.S. government seems to have stated a position that, this treaty process, it's not really self-enacting on the self-executing on the U.S. government. And so, what will happen next year, basically, when you have possible international treaty obligations under WTO? You will have a U.S. law that's written in such a way that arguably the government will have to enforce, and the courts will have to interpret all this somehow. Unfortunately, we don't have Judge Poe to opine on this, but perhaps the panelists can speak to it.
Well, I think the answer under U.S. law is pretty clear. There is a statute there's a provision in the Tariff Act of 1930 that addresses non-market economies, and it says what can happen to them, how to calculate their dumping margins. It also provides a 6-part test for how a country can apply to graduate from non-market to market economy status, and none of that is at all or in any way affected by the accession protocol of China to the WTO, which is not self-executing in the United States. There are countries in which the WTO agreements are self-executing, but we are not one of them. So there will be no effect.
Well, let me add to that. I mean, it isn't one of the treaties that the United States has signed as part of the WTO suite of treaties, right? I mean, it's China's accession protocol, and so there's a big gap there. It's not as if the WTO were actually interpreting, when the dispute resolution apparatus does interpret it, it's not like they're interpreting anything that the United States put its signature on. So the road is a tough one. But as I suggested, if it happens that the WTO goes down that road, they eventually issue an opinion sometime in 2018 by the process going through the system, and they say that China is entitled to have other members not assign it as a non-market economy, then I think if that case gets, and then it's going to get litigated in the court system here, and under current precedent, it will probably not succeed unless we can distinguish the precedents that pretty clearly say that the U.S. Supreme Court will not give a hoot as to what an international tribunal has to say on anything.
Let me just add that the whole non-market economy thing was actually created at the request of non-market economies. We're not talking about China, but we're talking about like Czechoslovakia in the 1980s who wanted to join the WTO, but because they were a non-market communist country, weren't going to be allowed to. So they negotiated, along with Poland and some other countries, like a sort of special treatment that notwithstanding you're a communist non-market country, we will let you into our trading club. And that's where this whole thing came from. And I guess my other point along that regard is that there is a provision that exists in the GATT, which was the predecessor to the WTO, and it is incorporated into the WTO, that excuse me, but I am a policy kind of wonk, but if there's a particular market situation in a country, an investigating authority can disregard prices in the same way that we now do for China, because it's a designated market economy.
So Professor Effen, do you have time for one question from the audience, maybe? Yeah, one. So any audience members, raise your hand, please. I see one right there. Please, yes.
Thank you. This question goes to Mr. Christopher Claudia. So just as Mr. William Perry has just mentioned, the non-market economy is a political decision, and you have also mentioned that following the 2006 subsidy cases, China retaliate, which implies that it's also a political decision. So where the trade remedy volume is only 1 to 2% between the U.S. and China. However, those cases has raised a lot of toward political issues, especially in China, has been used as evidence that the U.S. tried to impact the economic development of China. So you have both stayed in, you lived in China for 4 years, and in your observation, my question is, to what extent that both the U.S. and China have used trade remedy as political tool?
Okay.
So in another word, that is, to what extent have the rules being abused,
Okay.
and is it worthwhile?
Well, I'd like to start by disabusing this notion that somehow the United States is out to economically contain China. I mean, if the United States really didn't want China to develop economically, they wouldn't have allowed China into the WTO. Keep in mind, anti-dumping is very small. And the United States did allow China to accede to the WTO, and the results have been spectacular. Chinese economic growth is off the chart. And China is also unique in that it has written into its anti-dumping and countervailing duty regulations retaliatory provisions. These are not consistent with the WTO, right? Under the WTO, there is no self-help. If you have a problem with another WTO member, you may go to the WTO and litigate it. You may not impose some sort of retaliatory investigation upon that country. But China's unique in that it has those provisions written into the regulations. I will also point out that in the United States, an anti-dumping or a countervailing duty
investigation is a matter of right. Any producer of a product that is being injured by an unfairly traded import can petition the United States government to investigate, and the United States government is obligated to do so. The United States government has the option under the law of self-initiating investigations, but it has not done so in, I don't even know, 30 years maybe, William? It doesn't do it. So each U.S. investigation is requested by an industry that is that feels it's being harmed by imported goods. So the U.S. government really has no control over who files and couldn't stop us if we tried. I am not sure that in China it's the same thing.
The one point is that that's because there's a public interest test. In the United States, there's no public interest test. EU, Canada, and China have one. And so that can make for a difference. I mean, with a public interest test, MOFCOM can decide whether or not it's in the public interest to go forward with a petition or not. Commerce cannot decide. It just must do it.
Okay, well, thank you. Thank you for the exchange. It's been excellent having you all discuss the various aspects of U.S.-China trade tensions and sort of laying out the issues and explaining to us all. Thank you.
Thank you.
Thank you so much to our second panel and to all of the people who have participated tonight. And then finally, to close out our program, we will have a few words from the Dean. I just want to remind people that at this point, the only camera that we'll have is the BLS camera. And also, if you are a CLE participant, please remember to fill out your evaluation and return it in the back on your way out, and please join us upstairs at the reception. So,
in introducing her, Professor Efron neglected a very important qualification, and that is she was the driving force behind the Dean Search Committee that brought me to this law school, so I really am very impressed with her judgment and wisdom. Very grateful for that. You know, when you think about it, and I think this was implicit in Judge Kelly's remarks, you can't have disputes unless you have a relationship. And as a relationship grows and volume of business transactions grow, it's inevitable to be disputes. Why lawyers and what we're doing at this law school matters, and what this spectacular array of experts who on this panel and the previous panel have been addressing, is how disputes, which are inevitable, can be resolved thoughtfully and responsibly. You don't always have to win or lose to have a good business proposition, but I think that people who are engaged in trade and business need to know that there's a rule of law and legal recourse, and we'll get this going as this inevitable relationship continues to grow with you know, two of the most significant trading partners that the world has ever seen. I'm incredibly impressed, and you know, when you single out people, you're always at risk, but I should give a shout out to my great friend and college classmate. I guess he's off here, so he won't hear this. Somebody will have to tell him, but Bill Kovacic, who was here earlier. And then our own, you know, Judge Kelly, Noah Hamp, and Professor Zhao, who it's so great to have you. You were here teaching a class at midterm and at winter break, so that was just terrific to have you here. And all the rest whose expertise and knowledge has been so great to share. I'll end with one thing, and that is this law school is in Brooklyn, and Brooklyn is known for a bridge. But our bridges of this law school to China are not as well known as they might be, or I hope soon will be known. And for example, for 25 years, we have had programs bringing United States-based students to China to study law. And increasingly, we have made efforts. We have one of our admissions officers in China right now, has been there several times, discussing and talking about highly capable Chinese students to come to Brooklyn in order to study law, both JD and LLM levels, or as exchange students. And we welcome them, and I hope all of you will leave this place and have in mind people that you would encourage, either of Chinese heritage or based in China who would want to come here to study, or those anywhere who would be interested in the highest level of trade study. And so I'm going to make all of you disciples and recruiters and salespeople and ask you to get the word out. What is lesser known is that our relationship with China is long. Maybe not long in a Chinese sense, but long for an American sense. So for over 110 years, this law school has had a leading relationship with bringing people from China to the United States. My friend, Professor Li Chen, who is from Shanghai, is currently a visitor at St. Louis University, has published 2 articles recently and is soon to publish a large monograph about Chinese nationals coming to the United States between 1900 and 1920 and studying law in America. And they didn't find it a hospitable place to pursue legal careers, except in Brooklyn. Because, and this he's going to be featuring this, Professor Lee will be featuring this story in his monograph, but in Brooklyn, which has a reputation not only for being an edgy and super cool place, but being an open place, which was one of the first schools to take women in large number, people of color, people of working class backgrounds and so on, but it was one of the very first places that would welcome at a time when there was hostility Chinese for the study of law. In fact, there was at the time a legislation on the books in New York State that prohibited Chinese heritage people from being licensed to practice law. And the faculty of Brooklyn Law School, and Professor Lee, documents this, so you don't have to just take it from me, went to Albany and got a special statute passed that permitted graduates from this law school of Chinese heritage to practice law. So you may not have realized this, but today the wonderful program that Professor Efron and the Block Center has put on in conjunction with the Chinese Business Law Association is really a continuation of, for us, a long, and I hope to be longer and continuing tradition. Thank you all very much, and I believe that someplace we have refreshments that are served upstairs. It's great to see all of you. Thanks for being here.